Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. We are plodding along here. Plodding is not the right word. We are skipping along here through our new 2022 Commission Position Statement Update series. It's a series. And as I've said before, these Commission Position Statements have been updated. They are just hot, hot, hot. And I mean, they read like a Danielle Steele novel. It's really something that just keeps you engaged and engrossed. It's really good stuff. So check them out if you haven't already. I'm walking you through a bunch of the more pertinent ones for your business. And we've arrived at Commission Position Statement 6, Release of Earnest Money Deposits. All right? Listen, earnest money disputes in terms of hotline calls or brewing earnest money disputes in terms of hotline calls are, I would say, hands down the most common, consistent call that we get on the hotline. Brokers calling to say, yeah, we've got a little issue here. I feel like there's maybe an earnest money dispute brewing. Just without question, year in, year out, no matter what the market, one of the most consistently common hotline calls that we get. And so there's some good information in here for you with regard to that. It's always tough for as a broker because your clients are stressed out about it, particularly buyer brokers. You know, buyers got money hanging out there that they're going to need a release to get back, and they're bugging you, hounding you. You're trying to hound the listing broker or the title company. It makes it really tough. And so, anyhow, so CP-6 starts out with a statement that says this, and it's important to be aware of to calm you down as the broker. The Real Estate Commission will not pursue discipline against a brokerage for refusal to release disputed funds when acting per the contract terms. Okay? So this is a situation where you as a brokerage firm are holding earnest money. I think it's a very uncommon situation, and that's good because why would you, right? There's other people that are great at that, and I'll come back to that in a second. But you are, as a brokerage firm, you are entitled to hold earnest money. All right? It looks like brokerage firms are entitled to, or can hold them. It's can hold earnest money is what I'm trying to say there with a little abbreviation. So as part of your licensed activities that you're allowed to do is hold in trust earnest money for third parties if your brokerage firm has an appropriate trust account, and they're allowed to do it. It used to be a lot more common. I think that was probably when we used to have a lot more kind of small, maybe a little bit more fly-by-night title companies. And so there used to be, I believe, some good reasons that brokerage firms, in order to rely on the fact that money was being held well and in trust and could be relied upon. Brokerage firms used to hold earnest money. I think that's very, very uncommon now. And I think that's a good thing. I honestly think that's a good practice to not hold earnest money. But one of the things that they do point out is that there is not an earnest money release required. You don't have to have an earnest money release. The commission doesn't require an earnest money release. They provide a commission-approved form to allow the parties to release earnest money because it's certainly something that's used frequently. But the actual release is not something that is required by the Real Estate Commission. Earnest money releases are required by the earnest money holder in most cases because they want to see that if they're holding money pursuant to a contract and closing instructions, they want to make sure that the parties are in agreement with regard to the disbursement of that money before they cut a check. Because if they do it to the wrong person for some reason, guess who's probably on the hook if they released it to the wrong person and can't retrieve it for the right person? It's whoever's holding the earnest money. So it's not the commission that it requires or the Division of Real Estate that requires earnest money releases. It's the earnest money holder. And so be clear on that piece of the puzzle here. So if you're a brokerage firm and you do hold earnest money, then you're putting yourself in a place where you almost have to be the bad guy, particularly if you're representing the seller, and it's typically the listing brokerage firm that would hold earnest money on behalf of the seller for the transaction. And your seller's sitting there going, I'm entitled to this earnest money. The buyer completely defaulted on the contract. They've disappeared. I need you to release this earnest money to me. And you're sitting there saying, well, I'm not really comfortable doing that because I'd like to get the buyer's consent to release it to you. Buyer won't do it. Anyhow, you put yourself into a weird position for all of that. But another thing that the CP-6 points out is that when you're a brokerage firm or any earnest money holder, there is this unclaimed earnest money situation. And so the party who's actually entitled to the earnest money, for whatever reason, and believe it or not, it does happen, they disappear. You can't find them. You're sitting on this money in your trust account and you're like, I got to get this out of here. I have no place to send it. So there is in Colorado this Unclaimed Property Act, and you probably hear about that, and you should check. There's a website, the state, you can see if your name is entitled to any unclaimed property that's out there. It's something good to check out. But if you are an earnest money holder and you're sitting on this money where you can't get it back to the rightful party for whatever reason, they've disappeared, you are obligated to act in compliance with that. Essentially, you've got to provide notice to the last known address, and I think you got to wait like 180 days or 6 months after you provide that notice, and at that point you can transfer it to the Colorado State Treasurer's office and get it out of your bank account and rely on the fact that you've done that safely. The last thing that CP-6 addresses is third parties holding earnest money, which is hands down, thank God, the most common situation in the real estate brokerage world. That's going to be where title companies, which is probably the most common, and they're great earnest money holders, sometimes attorneys, sometimes builders, as sellers directly. Whatever the situation is, this is some third party holding the earnest money. And this statement right here, I put it in quotes because it's very, very important to understand. Brokerage firm is not responsible for the disposition of the earnest money deposit when the brokerage firm's not the one holding it. So that's a great reason, a best case scenario, to not be the one holding it, because the commission has essentially said through this position statement, hey, we're not going to hold you as a brokerage firm responsible for the fact that the parties are having this earnest money dispute over here. And I get a lot of people that call, a lot of realtors that call the hotline, and they're stressed out, they're worked up. And I know you're trying to do the best for your client, but at the end of the day, you should realize that this is not a dispute between you and the other brokerage firm, or you and the seller, or you and the buyer, or you and the other party. It's a dispute between the buyer and the seller. And there's the contract addresses what the recourse is for that, and remind me, and I'll do another Legal Bites maybe on some of the changes that we've had there. But remember that statement, brokerage firm is not responsible for the disposition of the earnest money deposit. So as much pressure and stress as the parties may be putting onto you to get this all wrapped up, and I know you're putting pressure on yourself because you want to do right by your parties, at the end of the day, remember whose dispute it is. It's the buyer and seller's dispute, not the brokerage firm's. All right? So that's why it is the best case scenario, I believe, to allow some third party, whoever the appropriate third party, in most cases, again, it's going to be the title company, let them hold the earnest money. Hopefully this helps, and if you have questions about earnest money disputes or earnest money holding or anything under the sun, within reason, I mean not anything under the sun, but use the legal hotline. It's a great resource. It's available from 9 to 12 and 1 to 4 Monday through Friday. Go to our website, check it out. You can sign up and get authorization to use it. It'll give you the phone number, and most of the time when I'm not answering, it's a really great resource. Take care, guys. We'll see you on the next edition of Legal Bites.